But still, when I'm done, it's like, I think you're right. So, yeah, it's great. Thank you. Yeah, I probably because they're actually face that. Thanks. Are these my sons? Well, through the surface through the TV. So you do have to, would you test those right there? Sounds really cool.
Testing.
It's not very loud.
Testing the room microphones.
Make sure people put their mouth too close to the microphone. To figure out the budget. Okay. That's or here in the room. I can hear the same about. It's all about the chat. Okay. Yes, it is. It's not all on me and Webex. So we do a little bit of combination. We'll just continue with the I should. I need to. March the 11th, I said I don't need to. But at this summer, we can. Is this still like a night thing? Yes. Because is it that same one he did? Is there really? I didn't know. I don't know. Well, they said the last time they lowered his temperature was still it's here. It's been sending it something. So you're saying so you guys just reminds you. No, yeah. See, what's about yeah, I did too, but it's so yeah. I grew up. Over the top. And you can shoot it. People. She's like, we just. Yeah. So. Yeah, that's not. Just a little bit. I don't know. I'm just so you don't have to pick that one fast. Oh, yeah, just need a stick. Yeah. We'd like to. Yeah. They're both. It's usually the other. Yeah. 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 But the chips has to go through. Such a good. All right. What do you think? I'm sure they just sort of all the way in there and exchange. Yes. Okay. Yeah. Let's prepare to begin, please. Record. All right. Sorry. Are we starting on preparing? Oh, sorry, starting on. Cheryl, you want? I had one. Oh, okay. Yeah. Yeah. That one. Oh. No. Yeah, well, I would, they have to call that a function order to tell yourself story. They seem to want to address something. I would just. Okay, so I'll put you guys everyone here to the mic. It was cold. Yeah, okay. I thought we were. Okay. Yeah.
It is. I'm just going to interrupt. It is very hard to hear you guys talking. I heard something about the order of us calling each other to order.
Yeah. Yeah. Or, oh, right. Right. Allergies.
Good morning, everybody.
Everybody in the room on the platform today. This is the EIB meeting and joint public hearing. It is
9:04.
March 22nd, 2024. Please excuse me
Having
having
allergies.
allergies. So sorry if my voice sounds stuffy here.
But to start off, I
I would like to do roll call first.
Miss
Miss
Jones.
Jones, would you mind doing roll call?
Yes, I will. I'm just looking online we have two remote members and I don't see them, but okay. Member Bitzer, are you present? Member Ely?
Present.
Member Garcia?
Here.
Member Honker? Vice Chair Trujillo?
Present.
Chair Sweeney?
Present.
I think we need to work on, Mr. Honker's working on getting in through the link I sent him.
Okay.
And it sounds to me like we're getting an echo. Buddy, you handle? Something's muting us, or something should be muted.
Unless someone has their. Okay, I'll hold the right team. So
Miss Jones,
shows that we
wait a
wait
minute.
to see if we get the IT.
We could, did you say that the Albuquerque board needed to do a roll call as well? We could let them do theirs.
Yeah.
We'll let them.
They'll do theirs too, and then maybe turn it over to the Albuquerque board. So I see legal counsel, Cedilio, and I see Chair Paul. So the floor is yours.
Great. Can you guys hear me okay? No? I'm not on mute.
I can hear you, Chair Paul. This is Vice Chair Richards.
Okay. Glad you can hear me. Can the hearing officer, Ms. Felicia hear me? Uh-oh.
Oh, we can't hear them. Yeah.
No.
We can't hear you.
I'm not sure what to do about that. Should I just keep talking? Testing? Nope. Not getting anything. No thumbs up. Thumbs up if you can hear me now. Okay. I'm not sure how to help you guys. I could try. Is there a call-in number? Yeah. Okay. So folks on the platform can hear me, but thank you, Mr. Maxwell. But they can't hear us. Okay. How are we gonna do this? We could call in by phone if that's an option.
Madam Chair, they are getting an IT person, so I since they can't hear you, might as well just wait until the IT person addresses it.
Thank you. While we're
Chair Paul. Well,
yes.
In a minute to see if we can do another test. So. Hey, Isaiah, this is David. None of the sound is working. Yeah, we're not that much. Thanks. It's across the resident. But yeah. What she does is she takes it to sheets. And just to be information. Yeah. I get some. Legal counsel. We can't take her. Okay, Ms. Bowen, can you hear us? Put a thumbs up.
I hear Chair Svina talking,
Okay.
but I don't really hear what you're saying.
We're thinking just in the essence of time, is that we could, and we have member Hunter as well. Member Hunter, would you mind doing your videos, we can see?
I did not fully hear that. I'm not sure if you're talking to me.
Or just,
Yeah, it's very garbled.
Oh, it said speaking, then the host, no sound. We can change the,
Now, the hearing officer, Felicia Orth, her voice came through fine. Everyone else's voice is coming through garbled.
we have, I can see the testing. You want a different layout? Is that what I'm hearing?
Yeah, can we try the layout where we want to see the videos?
Oh,
The bottom one had participants without video.
which one?
It was the bottom one in the drop down. I'm participants without video. So down. There you
And then you make sure they have video when they speak. Make sure they're. They're speaking. Now on video, I don't know what it is.
There's also an option there to do, for whoever is speaking, that their picture comes up. The people focus.
Yeah. Yes. Only, but no, the voice to be. Yes. It's so true. And I think I let Mr. Hooper in. Let me just check if he's in. Yeah, see, he's on the screen. He's just here.
How much this video so that we. Recording the stop video on.
Or Miss Chair Paul, could you do a test 1, 2, 3?
I heard Chair Paul, and then it got digital. And maybe a little of one other word.
Well, we can hear you now. Can you hear me?
You sound like a robot. But I did hear what you said.
One, two, three. Do I sound better, Chairful?
Yes, much clearer, quite quiet. If you can turn up the volume, I can turn up my volume too, but I think I usually have it on.
Do another test 1, 2, 3.
Perfect. There we go.
Okay, great. Thank you. Okay, I think there's a echo though.
There is a bit of an echo, but it's not as bad as it was before.
Let me do another test. 1, 2, 3. Somebody, their computer on, just coming from us.
Got a lot of talking to do today.
So somebody in the meeting room may have the volume up on their laptop if they've got it on the laptop, and just turn your volume all the way down on the laptop. I think that's where the echo comes from.
I'm gonna do another test. 1, 2, 3.
So if we remain muted, if everyone in the WebEx remains muted, unless they're speaking, we should be able to do this.
I'll do a test. 1, 2, 3.
Clear over here.
Sounds
Okay.
good to me.
Does that work?
I think so.
All right. Okay. Thank you to our IT specialist here at the Capitol. Appreciate that. Appreciate her help. So we will get back to our meeting agenda. All right. I would like to just redo our roll call vote since we do have another board member on the platform here. Ms. Jones, now that we have our IT issues worked out, can you do a roll call vote? Yes, I will. Member Bitzer, have you joined us? Okay, Member Ely? Present. Member Garcia? Member Honker?
I'm here.
Vice Chair Trujillo?
Present.
And Chair Sweeney? Present. We have everyone but Mr. Bitzer. We'll continue to try to connect with him. Thank you, Ms. Jones. Appreciate the roll call. And again, thank you for everybody's patience as we navigated the IT issues. And number 2 on our agenda is the approval of the March 2020 or 2022, March 22nd, 2024 agenda. Is there any changes that we see, fellow board members? Nope. If we don't have any changes, I'd love to entertain a motion.
I've moved we approve the agenda for today's meeting.
Thank you, Member Honker. Thank you, Member Garcia, for your second. No further discussion. Ms. Jones, please do our roll call vote on Member Honker's motion to approve the agenda. Member Ely, how do you vote? Approve. And Member Garcia? Yes. Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney? Yes. Thank you, Ms. Jones. All right, we're on agenda item number 3, which is the approval of February 29th, 2024 regular meeting minutes. Those meeting minutes have been distributed, and I'm looking around if there's any amendments, revisions, changes. Not? Looking for a motion.
Yeah. Wait a minute. This is Member Hunker. I've got on item 7. I think the language is confusing. It's that was the hearing that I acted as hearing officer, and 3 times in that discussion it refers to me as chair instead of hearing officer. So I think we ought to change that to hearing officer just for consistency and to avoid confusion with the chair of our board.
Thank you, Member Hunker. So those would be the revisions to incorporate. Are there any other revisions that folks saw? Right? Looking for a motion?
I move we approve the minutes for the February 29th, 2024 meeting with the three changes that I just proposed.
Thank you, Member Hunker. Thank you for a second. Thank you, Member Garcia, for the second. No further discussion or revisions. Ms. Jones, would you please do a roll call vote on Member Hunker's motion?
Yes. Approve the amended minutes. Member Ely, how do you vote?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
And Chair Sweeney?
Yes.
Minutes are approved.
Thank you, Ms. Jones. With that, we will be going to agenda item number 4, which is public comment. And these are general comments not pertaining to any meeting agenda items for today. Looking in the crowd and then toward Ms. Jones, is there anybody or Adai on the platform that would like to make a public comment?
No one has reached out to me to make general public comment this morning, Chair.
Thank you, Ms. Jones. And so I'm looking around the room. I don't see any other individual raising their hand. So we will move on to agenda item number 5, which is EIB 24-12 in the matter of proposed repeal and replacement of 20.2.71 NMAC, operating permit emission fees, and 20.2.75 NMAC construction permit fees. Request for hearing, appointment of hearing officer. And we have Mr. Prince, counsel for NMED. And thank you for coming today. Ms. Keene. Thank you so much. The floor is yours.
Thank you. Good morning, Chair Sweeney, members of the board. My name is Michael Prince. I'm Assistant General Counsel with the Municipal Environment Department, representing the Air Quality Bureau in EIB 2412. We're here this morning before the board on the petition that was filed earlier this month to repeal and replace 20.2.71 and 20.2.75 Mexico Administrative Code. Those two parts, Part 71, 75, the permitting fees that Air Quality Bureau collects as part of its regulatory duty to carry out the Clean Air Act, state air quality control regulations. Also at the table, I meant to introduce our Elizabeth to my right. He is Air Quality Bureau Chief. Left, Michelle Miano, Director of the Environment Protection Division. Okay, so we're just here before the board to request that the board take this matter up and schedule a public hearing. We are requesting the dates of June 10 and 11, which are a Monday and Tuesday. And also the appointment of a hearing officer. I think this room, if the board takes it up, this room is probably adequate for we do expect some public interest in these whole changes. With that said, I mean, unless you have, I stand for questions this time, or if you have colleagues.
Thank you, Mr. Prince. Do you have any questions? Yes, Member Ely.
Mr. Prince, do you anticipate any petitions being filed in opposition to the?
Thank you. At this time, I don't personally. So, yeah, my colleagues say no.
Thank you, Member Ely. Do you have any questions? Yeah, Vice Chair Trujillo.
Yeah, just a quick one here. When was the last time these were updated.
Thank you. Mr. Chair Trujillo. It's been about 20 years since these fees have been updated. And since that time, especially over the last 12 years, there's been a significant increase in the number of permits, oil and gas permits that have been, applications and permits that have gone out. Also been some changes to federal and state air quality regulations. For example, the ozone precursor rule that this board adopted a couple years ago. And so there's been an increase in workload in the complexity of the work the Quality Bureau has to do in order for it to effectively and efficiently do its job. This revenue be updated.
Thank you for that response, Mr. Prince. Any other questions from members of the board? I also want to note that Member Bitzer has joined us. Good morning, Member Bitzer. Thank you. For our members on the platform, do you have any questions of our presenters this morning? Nope. Yes, Ms. Bowen.
Good morning. I just wanted to check, are the dates requested for the hearing flexible, or are those, they need to be June, I believe he said 13th?
Thank you. Question. Those are our preference for the two dates. Bureau's eager to try to get this as quickly as possible. We'll, of course, work with the board. Those are our preference.
Okay, great. Thank you.
Great question, Ms. Bowen. And can you repeat those dates again? I think you said June 10th and June 11th?
Correct.
Okay. All right. Is there any other items, other presenters would like to share comments that we consider? So members of the board, we have a request for hearing from the department for June 10th and the 11th. And just check you one more time that you do think both days will be needed or sufficient?
Yeah, I think 2 days will be sufficient.
Okay. Wonderful. Ms. Bowen.
Yes, Chair. Oh, I'm sorry. My hand is still raised. That was an accident. Thank you, though.
Chair, I have I guess a point. Seems like if it's going to be a 2-day hearing and since we're talking about increasing fees, I would guess the universe of permittees and folks impacted by this would be substantial. There may indeed be some opposition or comment from the regulated community. So it sounds to me like we should probably get an external hearing officer for this rather than one of the board members doing it.
Thank you, Member Hunker. I appreciate that input. Is there any thoughts to that? Yes, Vice Chair Trujillo. Okay. Wonderful. So with that, I think, what does the board think about the dates? Are those dates amenable? Yes, Vice Chair.
I believe we've done enough. Would
I can't hear any of the discussion that's going on.
Oh, okay. Sorry, Member Honker. I was just suggesting that we couple it with the end of the month hearing or regular meeting, so the June 27th, 28th.
Would that be amenable to the department?
Yes, that would be.
Thank you. And Member Hunker, can you hear us now?
Yeah, very clearly, thanks.
Okay. Yeah, so with that, we have a couple of different dates, looking at our end of the month meeting date. Is that amenable to fellow board members? Is that a good date for you? Yes, Member Ely?
Sorry about that. Don't touch your mic. I can probably be available at the end of June remotely, but I don't know that I will be here in Santa Fe. So I guess we need to determine if we'll have a quorum. Dates being considered.
Okay. Yeah, so looking at the other board members, Member Hunker, Member Garcia, Member Bitzer, Vice Chair, thumbs up, the end of the month, either day? Okay, same for me. And I think we might still have a hybrid option, so you could participate. All right, so I think we've got a number of items and consideration and details, logistics on the floor. And as Member Hunker discussed and commented that maybe a hearing officer, is there a Ms. Jones? Oh, okay. Hearing officer that would be available toward the end of the month in June?
I would have to poll them,
Okay,
find out if those dates are available.
okay. All right. So we would probably have to determine the outside hearing officer if that's the way the board would like to proceed. So just want to put that on the table for any potential motion that is framed. Thank you. Member Garcia?
If you don't anticipate this being why do we
I can't hear Member Garcia.
Can you hear me now? No? Can you hear me?
Yes.
Okay. So my question is, if this is non-controversial, why do we need 2 days?
Yes, thank you, Member Garcia. So at this time, yeah, we've done some public outreach and we haven't, generally the reception has been generally positive. We figured 2 days, well, these are two different sections. It's just basically to build in extra time if there is opposition, or just to be sure to cover, all the bases, questions from board members. So that's why we figured, just to be sure. Go in one day, possibly.
Okay. Thank you. So you've run it by industry, obviously.
Yes, I
and
did.
So far, there's no opposition.
Correct.
Okay. Thank you.
Thank you for that clarification, Member Garcia. With that, do any of the members want to propose a motion regarding this NMED's request?
Sure.
Yes, Member Ely?
I move that we move forward with the petition as proposed by the department with a hearing date that coincides with the EIB's regular meeting in June, and that we consider or look for an outside hearing officer.
Thank you for that. Ms. Bowen, do we need to define a specific date? What's your guidance?
In order for me to write the order, a date would be helpful. It sounds like everyone had agreed on the 27th and the 28th. And I can write it as we have in the past, where it starts on the 27th and continues as needed, if that's how you folks want it. As for the hearing officer, it doesn't need to be specified, just needs to be specified that you folks want to appoint a hearing officer.
Thank you, Ms. Bowen. Yes, Member Hunker? Yes, Member Hunker? Your hand up.
Sorry. I would amend the motion to authorize the Chair Sweeney to work with NMED to identify a hearing officer.
Thank you, Member Hunker.
And
Yes,
if we
Member
need
Ely.
specific dates, hold the hearing on the June 27th.
Okay. So for the record, Member Ely, would you just want to amend your motion for those two amendments?
So I move that we hear the petition as proposed by the department and that the hearing be held on June 27th and June 28th as needed. And that Chair Sweeney work with the department to find an outside hearing officer for that hearing.
I'll second that motion.
Thank you, Member Ely and Vice Chair Trujillo. Looking for any further discussion, motion on the floor, none seen. Ms. Jones, would you please do a roll call vote on Member Ely's motion for setting a hearing date and a hearing officer?
Yes. Yes. Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
Motion passes.
Thank you, Ms. Jones. Appreciate the discussion and thank you, Mr. Prince and the guests for being here this morning for this request and have a wonderful rest of the day. With that, we'll go to our next agenda item, which is EIB 23-56 joint public hearing with the Albuquerque Bernalillo County Air Quality Control Board in the matter of proposed amendment to 20.2.91 NMAC, new motor vehicle emission standards, NMADA, motion for stay. Armando de Garcia, motions for stay. We do have a number of attorneys here this morning for this item. And before we get to that, I did get a notification that the Albuquerque Bernalillo County Air Quality Control Board needed a logistical matter to address too as well. So I will turn it over to Chair Paul.
Thank you, Chair Sweeney. Wanted to make sure that we address an OMA issue that came up. I think I don't know that we have to go through maybe council can help me here. Do we have to go through our entire agenda, or is some of that supposed to be in parallel with what's already happened at EIB? So should we be calling for our own public comments and our own agenda items here, or can we just address the issue and then move on to the hearing?
I think that you should first call roll and see whether you have a quorum. And then
that's correct.
I think you should address the issue, the logistical issue first, because then after that, and then go through the agenda.
Okay, great. So I'll call this March 22, 2024 special meeting of the Albuquerque Bernalillo County Air Quality Control Board to order. The time is 9:40 in the morning. Ms. Estiarmijo, would you please call the roll?
Good morning, Member Armijo.
Here.
Member Kalman.
Here.
Member Eberline. Absent. Member Galuski.
Here.
Vice Chair Richards.
Here.
Chair Paul.
Here.
Madam Chair, you have a quorum if 4 or more people are present.
Great. So we have a quorum. We can move forward. Our second item is approving this agenda for today. I'd like to add this additional issue. I'd like to put it first on the agenda. So can I have a motion to approve the agenda with the addition of addressing an OMA issue?
So moved.
Moved by member Golewski. May I have a second?
I'll second. This is
I
member.
second.
I got member Kalman first. Sorry, member Amiha. On the second there. Assuming no further discussion, please raise your hand if so. We can move on to a roll call. Ms. Esther Amiha, would you please call the roll on approval of the agenda with that addition?
Member Armijo,
Yes.
Member Kalman,
Yes.
Member Eberline, absent. Member Golewski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul.
Yes. So I believe that's correct me if I'm wrong, 5 yeses, 0 no's, and 1 absence. So the amended agenda is approved. So now we can address this first new item. My understanding is our notice for this special meeting was about 2 hours late. That's just to the best of my knowledge. We don't have an exact timestamp on that. Council, do you want to expand on this issue?
Yes, Madam Chair. I'm not sure exactly how late it was because, well, as you know, I had sent out the wrong notice to the board the night before, or to Ms. Esther Amijo, and then she doesn't even start. She wasn't there, but she starts the day very early, and so she correctly found the right notice on, I believe, on the website for EIB. But my understanding, and I'm still not clear about the timing. My understanding is it did not go out by 9 a.m. And maybe due to the just delay in looking at the EIB, looking for the EIB thing. And then my understanding is the notice to the parties and the notice to the public went out. I mean, I got it at 11. And so I did some research, not exhaustive research. I did some quick research, and I didn't find a New Mexico case on substantial compliance. I did find other states that look at substantial compliance and excuse it, especially if there were just technical glitches. But in New Mexico, what it does have is it has the ability to cure. It very clearly, you can cure a problem with notice and by just republishing. And so because this hearing is a unique joint hearing, my suggestion would be to go ahead and have this hearing, but not vote, but republish the notice and then have a special meeting. You could have it, if the notice went out today, you could have it as early as Monday afternoon. Or we could also ask the hearing officer to decide whether that notice was sufficient and decide then whether you have, whether you want to decide today. It was a technical violation. It was not intentional. And when you read the cases, they really hate intentional violations. And, you know, that's basically where we are.
Thank you, Council.
Yeah, I'm happy to answer any other questions.
Yeah, does anyone, any members of the board want to comment on this or have any thoughts? Open up the floor.
This is Member Armijo.
Go ahead.
I think we ought to just, as Antoinette suggested, is go ahead and let's hear the thing today. We don't have to decide whether we're going to vote on it right now or not, but we've got all these people sitting here waiting to hear this thing. And I think we ought to just get it over with. Thank you.
Thank you, Member Armijo. Anyone else on the board? Hearing no further comments, I agree that you know, it's strange for us to vote on our own issue. Perhaps Ms. Orth can make a determination as to whether or not we can proceed. but I also like this suggestion by council where we are here to listen, and maybe our vote comes separately later after a accurately published or a timely notice. So that is what I'd like to hand to you, Hearing Officer Orth.
Thank you, Chair Paul. I'm going to decline to offer your board legal advice about the Meetings Act. I will note that there is complete identity of parties, witnesses, counsel, and issues to be decided in the motion for stay before the state board and the motion for stay before the city board. That's all I'll observe. There was, of course, timely notice for the state board. So I don't think there's any problem with hearing this morning, but I'll leave it to you all to decide whether you intend to vote later today or. So, is there anything else that the city board needs to do?
I think we just want to vote on whether or not we're going to vote now or perhaps at our next regularly scheduled meeting.
All right.
Is there a motion on that issue? I think that might be a way to solve this, is that our actual vote comes in our next meeting, which doesn't change anyone's schedule, but we still get to hear all the arguments as they would be identical, as noted. Yeah, can I have a motion to that effect?
This is Member Armijo. I so move.
Thank you. Moved by Member Armijo.
This is Vice Chair Richards. I had a question for council. Are we, with this motion that we have to basically, I'm assuming, I'm not clear on the motion, is the motion to listen in and then vote at a regularly, a future special meeting? And if so, my question is, are we able to ask questions of parties during this meeting, or are we simply just listening and then voting at a future meeting?
Well, I would suggest that since you are going to make a decision, and if you have questions, that you go ahead and ask them. One of the things that Member Armijo suggested is waiting to decide when you're going to decide until after, because the vote by the EIB may influence whether you even need to have another meeting. Just depending on how it goes. So you may want to wait until after the hearing to decide when you're going to vote or whether you're going to vote.
Thank you for that information.
Do you
That's
have
all I had.
a motion? Vice Chair Richards, would you like to make a motion to not decide when we're going to vote, but know that we're not going to vote now? However you'd like to relay that.
No, I don't want to make a motion.
Okay, so we have a motion on the floor by Member Armijo to delay the vote on this hearing until the next regularly scheduled meeting.
Madam Chair, the next regularly scheduled meeting is too late. You have to make a decision within 60 days, so you'd have to have a special meeting.
Thank you, Council. Okay, so that leaves us with special meeting in the next properly noticed before 72 hours of an undecided date as an option. Okay, just to do the vote. So
shall I amend my motion?
Great.
Okay, I move that we go ahead and hear the evidence presented today, set a special meeting, and have a vote on the issues before us at the special meeting.
Great. Would anyone like to make a second or a competing motion that says we will wait to decide, as council reiterated, there may be, if EIB does decide to do a stay, sort of our question of whether or not we would decide to do a stay is moot because there would be a stay statewide. So okay. I will second your motion. Remember how move this along. Are there any comments or discussion? Okay, Ms. Esther-Mijo, would you please call the roll?
Member Armijo,
Yes.
Member Kalman,
Yes.
Member Eberline, absent. Member Galuski,
Yes.
Vice Chair Richards,
Yes.
Chair Paul.
Yes. All right, the motion passes 5 yes, 1 absent, 0 no's. So we will not vote today, but we will have another special meeting within the 60 days to actually decide on this matter. And thank you so much for your patience. I think we can hand it back over to the hearing officer, Felicia Orth, to continue the joint hearing.
Thank you very much, Chair Paul. My name is Felicia Orth, hearing officer appointed by both the Environmental Improvement Board and the Albuquerque-Bernalillo County Air Quality Control Board to conduct a hearing in this matter, which is 2 motions for stay in EIB 23-56 and ACCII 2023-01, both related to new motor vehicle emission standards. The motions for stay were filed by Automundo Garcia and the New Mexico Automotive Dealer Association. There were joint motions filed at the end of February. Joint responses came from the New Mexico Environment Department and the Advocate. Joint reply then was filed by Automundo de Garcia and New Mexico Auto Dealers Association. Hearing was set for today, March 22nd, again, as part of the EIB's already scheduled meeting. I met with council and Mr. Maxwell on a virtual platform and issued an order, a procedural order, to try to proceed through the arguments and evidence on the motions for stay expeditiously. As part of that order, the parties each have 15 minutes for opening argument, 15 minutes for closing argument, right? And 1 hour each for the witnesses, all of whom had to be noticed up earlier this week with their testimony and full narrative. The rest of the board members have reviewed all of that before coming here. 3 witnesses from the movements, 4 witnesses from the climate advocates, 3 witnesses from the Environment Department. They each have 15 minutes to summarize their testimony, and we will proceed from there. There was also another order issued around Ortiz Exhibit number 14, which will be offered as part of Mr. Ortiz's testimony. Testimony will be taken under oath, subject to cross-examination, pursuant to both boards' procedural rules. We'll ask counsel to exercise restraint in your cross-examination. Again, so that we can get through this matter today. So, move-ins. Would you like to offer your opening statement? Well, let me ask for appearances first, and then invite opening statements. Mr. Domenici?
Mr. Domenici, I think you push the button.
Good morning, Madam Chairs of both boards, members, Madam Hearing Officer. I represent both movements, Automundo Garcia and the New Mexico Auto Dealers, on the motion for stay.
Thank you. Mr. Knight? Thank you. And going forward, Mr. Knight, we have to ask you to speak into the microphone. Otherwise, the folks on the platform cannot hear you. All right. All right. Mr. Bach.
Thank you, Madam Hearing Officer, Chair Sweeney, Chair Paul, members of both boards. David Bach, representing the Climate Advocates. Co-counsel, Charlie DeSalen. Charlie, would you like to? Or Coalition for Clean, Affordable Energy.
Thank you very much, Mr. Bach. And I believe I saw Mr. Maxwell on the platform. Mr. Maxwell? Thank you. All right, Mr. Domenici, if you would like to offer your opening statement, and you will see me using my cell phone here as a timer.
Thank you, Madam Hearing Officer. I've given an abbreviated version of this argument to the Air Board, but since this is the sort of the formal record, I'm going to go back. I apologize to the Air Board if some of what I'm saying is repetitive. My clients have a statutory right to request a stay under the Air Quality Act, and it's more than a right, it's an obligation. So if we want to stay any part of this regulation, we have to go in front of both of the boards that issued the regulation to request that stay. If that is denied, we have a right then to ask the Court of Appeals for a stay. So we are following our statutory right and frankly our statutory obligation. There is a well-founded purpose as to why stay motions like this are allowed. They're put in statute, recognized by the legislature. They're part of the administrative process of rulemaking. They're also used in other circumstances, but I'll focus just on this rulemaking. And the basic purpose is to give the appeal time to be determined before the parties affected by the rule suffer irreparable harm. And they, what the courts have done is set up a balancing test or a test, so they don't say every rule automatically is stayed. They could have done that as a legislature and said, the board passes the rule, but then it doesn't take effect until the appeals are finished. But they chose not to do that. So some rules certainly do take effect and don't meet the burden that I have to establish for my clients. I have to establish good cause for you to issue a stay. I also am allowed to ask for a very defined stay, a restricted stay. So I don't have to ask that everything you decided be stayed. And we are asking for only a very narrow relief. And in fact, the EIB board rules require that we submit a proposed order when we file a motion like this, so that we actually have an order uh, that sets out what we are specifically asking for. And in essence, we are asking only that the ZEV portions of ACC2 be stayed until the Court of Appeal has a chance to hear my client's appeal. We are not asking you to reverse your decision and to say we made a mistake. That's not our burden. And of course, if that was our burden, then we wouldn't have any possibility of success because you've already made a decision. We need to show that we have a likelihood of success. That's been interpreted to indicate that we don't have a frivolous appeal, that we have some merit to our appeal. And I'm going to sort of jump ahead and indicate the reason that we are, and then we also have to show irreparable harm is a possibility if the rule takes effect and is not stayed. And the circumstance that we are extremely concerned about is that a rule of this nature, which we have, Bill, and I'll describe several very key appellate issues, will take effect, and the manufacturer mandate of delivering 43% electric vehicles or ZEV vehicles by model year 2027 will actually be occurring while this appeal is still pending. If that takes place, and this is testimony from Carlos Garcia, he will indicate that he's already put this in his written testimony. Model 2025 models are arriving now. One of the parties indicated that they look at Garcia's website. They have 10 Model 25 models currently, but they will extremely rapidly receive 2025 vehicles. The same will happen in 2027. So in the spring of 2027, 2 years from now, 2027 vehicles will be delivered. And under this regulation, and we understand there's a system for credits, taking into account credits, which might provide some benefit, there will be an enormous shift of what's been occurring and what we think the market supports. Manufacturers will have to deliver 43% ZEV vehicles to all of the dealers in New Mexico for that model year 2024. What Carlos Garcia says is if that occurs and then your regulation is overturned by the Court of Appeals, it will take years to recalibrate to correct the market conditions. Those vehicles will have arrived on lots that are unable to sell them. There will be financing attached to those vehicles that will place those dealerships in extreme financial hardship. The manufacturers will have had to gear up and allocate those kind of units to New Mexico for their model year 2027. And all of that could occur while this appeal is pending. So we are not asking you to stay several portions of this rule that have been indicated and we haven't disputed will provide significant benefits. The ACT portion, the NOx portion, we're not asking to have any effect whatsoever on that. We also think that the credit portion of this rule can continue as it is anyways. Manufacturers always record their sales and they would be able to come in and apply for the credits, whether it's after this appeal is decided or during the pendency of this appeal. If the appeal is decided favorably to the petitioners. So the credit portion of this, we don't think will be affected. What will be affected is there may be multiple valuable vehicles delivered, expensive vehicles delivered that will not have a market for them in the spring of 2027, 2 years from where we are. And you have the ability to stay that obligation while the Court of Appeals hears the decision. We filed our docketing statement yesterday, and that's sort of one way to identify what we think are the likely issues we have a likelihood of success on. With our first issue we mention is we don't think that either of these boards received the right advice and performed the right analysis as to how the equivalency requirement or identicality requirement of Section 177 of the Clean Air Act applies. You were told that once California adopted Clean Cars 2, Clean Cars 1 would not be in effect in New Mexico. That is simply incorrect. More importantly, you were told that you did not have the ability to divide out ACC2 from ACT and HDO, or those three components. Those are three separate regulations being promulgated through California. Completely different regulations. They all have separate waiver requests to the EPA. We ask that you look at the evidence and determine that the evidence did not support Clean Cars 2. And we informed you that much of the benefits you've been heard about applied to the other portions of the regulations that we were not challenging. You were told you could not separate out those three actually completely separate, unrelated regulations and had to vote on all three as a block. That was how you were informed, and that's how you voted. That is incorrect. And we think the Court of Appeals will indicate that when a rulemaking occurs, you are allowed to go into that rule and adopt portions of it and reject portions of it. You were allowed to reject the ACC2 portion and adopt the others. In fact, there was no evidence opposing the others, so you certainly would have. The climate advocates actually thought the same thing and requested that. In their closing argument, they thought the exact same analysis and requested that take place. You were told you couldn't do that. You were not allowed to vote separately on ACC2. We think we have a likelihood of success on that issue. Now, I'm just going to very briefly summarize the evidence you're going to hear today. And you're going to hear a lot of evidence that sort of carries forward from what we heard at the hearing. Questions about how electric vehicle marketplace is performing, questions about how manufacturers are performing, and infrastructure. Frankly, none of those really matter, in our view, anywhere close to the issue of, will there be irreparable harm? Can we establish irreparable harm? There is simply nothing to show that there will be a demand for 43% electric vehicles. The most telling evidence of that is what the US EPA did 2 days ago. This was mentioned in the testimony of the climate advocates. On March 19th, the EPA rolled back their target, which was 60% electric vehicles in 2030. Our target, or your requirement, it's not a target, is 68%. But the EPA their proposed rule was even less than that. They rolled that back to between 31 and 44% is now the current federal rule for 2030. Your rule is 68%. So the EPA, the federal rule, which came out 2 days ago and looked at all of the same elements you're asking to be looked at, indicated that what you're trying to do is about twice as aggressive as the federal government is willing to try to mandate. And they provide more flexibility in that. It is not a manufacturer requirement, it's an emissions requirement, but they clearly indicated that they heard that 60% was too aggressive. They heard that the manufacturers did not believe the market was there, that the market isn't there, and they rolled this back significantly. Our dealers are going to show the same thing. They're going to show the market. Our testimonies show the market has been flat. We've only been 4 months since we were here before, but it's remained flat. Yes, some of the infrastructure is moving forward as expected. That infrastructure may support the numbers like the EPA has proposed, may support something quite short of what you are mandating, but it's going to be helpful. So we're not going to dispute that some infrastructure is going in. It's not sufficient, and it's not going to change the needle anywhere near enough that there will be no irreparable harm if my clients all have 43% ZEV vehicles in 2 years from now. The market is supporting 8%, 10%, and this regulation remains on appeal, and 6 months later or 9 months later, it gets reversed. And my clients have already had to have those vehicles sit on their lots, sell their ICE vehicles, not be able to replace those, have to lay off employees, close businesses, default on loans, all of those aspects. This is a conservative, cautious, middle ground, narrowly focused, that allows everything you're trying to accomplish to continue, all of the infrastructure efforts to continue, but protects from this potentially irreparable circumstance that the appeal is successful, but the damage is already done. So in light of that guidance, that opportunity, frankly, for you to take a narrow view and eliminate one of the potentially harmful impacts of this rule while allowing virtually a huge part of it to proceed and allowing the infrastructure to continue to be built up, allowing people's knowledge and comfort with electric vehicles to continue. All of that can continue. What we're asking is for you to stay this potentially irreparable effect while the appeal is pending. Thank you very much.
Thank you very much, Mr. Domenici. Mr. Maxwell, I'm not sure if you have testimony you'll be offering later, but let me ask you if you had any kind of opening statement prepared apart from the testimony to add to Mr. Domenici. Okay, please go ahead. Thank you, Mr. Maxwell. Mr. Knight? That's fine. Mr. Bach, you have the same choice. Alrighty, thank you.
Before I begin, I know my witnesses had the same question. Are we going to be able to see the members who are not? I don't need it for the opening argument, but I know witnesses would like to see, if there's questions.
So at one point, I had thought that the staff indicated that the screen could be cast to these additional screens up in the ceiling. Pam, would you be willing to ask them if they could do that? Okay. While she works on that, though, why don't you go ahead?
Yes. Thank you very much. Madam Hearing Officer, Chair Sweeney, Chair Paul, and members of the board, both boards. David Bach on behalf of the Climate Advocates. With me today is my co-counsel, Charlie DeSalen. Also with me are Climate Advocates technical witnesses, Kathy Harris from Natural Resources Defense Council, Aaron Kressig and Deborah Kapoloff from the Western Resources Advocates, and David Bradley from Magpie Motors in Albuquerque. It is important to remember why we are here today. We are here to consider motions to stay the Advanced Clean Cars 2 regulation, pending a ruling dealer's appeal. We are not here to reconsider the decision to adopt the rule in the first place. In November, we had 4 exhaustive days of technical testimony, public comment. The Environment Department and Climate Advocates submitted thousands of pages of detailed analysis showing that the rule would deliver immense benefits for New Mexico, saving lives, reducing costs to consumers, helping avoid devastating climate change. The boards voted to adopt the rule, finding that it was in the public interest to do so. The dealers haven't asked to reopen that decision, and it would be improper to do so. Rule changes must go through a stakeholder process that allows all interested parties an opportunity to participate. That's not happening today. Members of the public are not being permitted to comment at this hearing. We have dozens of members who would like to voice their continued support of the rule, but are not allowed to speak today. So that just kind of underscores the importance of not relitigating the merits of the rule this time. And that's not what the dealers have asked us to do. Even though their testimony talks a lot about why they disagree with the rule, wish it hadn't been adopted in the first place, what they are asking for is a temporary stay while the Court of Appeals considers their appeal. Because we are here on a stay motion, the dealers bear the burden of proof. They must show that each of 4 equitable factors supports granting a stay. Those factors are a likelihood that they will succeed on their appeal, irreparable harm or the appeal can be decided, that a stay will not substantially harm other persons, and that a stay is in the public interest. New Mexico law is clear that if any of these factors is missing, the motion fails. It is very difficult to prove all 4 factors, which is why stay motions are rarely granted. The dealers have to prove all 4 of these factors, but in fact, they can't prove any of them. Let's start with the likelihood of success. The dealers certainly have not shown that they are going to win their appeal. Court of Appeals is very deferential to agencies like the boards here in reviewing regulations. As best I can tell, the New Mexico Court of Appeals has never set aside an EIB air quality regulation before. The dealers haven't identified any legal error in the rulemaking occurred. Their main argument seems to be that the board adopted the rule based on an incorrect interpretation of the Federal Clean Air Act. But that is just a complete mischaracterization of what happened in November. No one in November ever said that the EIB and the Albuquerque Bernalillo Board were legally required to adopt Advanced Clean Cars 2. Nor does the evidence show that the boards voted to adopt the rule based on a misunderstanding about how the 3 rules work together. The evidence is very clear. Both boards voted to adopt Advanced Clean Cars 2 because the weight of the evidence showed that this rule delivered important benefits to the state and Bernalillo County. But this argument is not likely to prevail. Beyond this mischaracterization, the dealers argue that the record does not show that the rule is technologically achievable or economically reasonable. There is ample evidence in the record that supports the board's findings that the rule is both achievable and likely to deliver substantial economic benefits to New Mexico. For example, Climate Advocates presented evidence that companies like General Motors, Volvo have committed to transition to 100% EVs by 2035 or even earlier. Countries in the European Union have seen dramatic increases in EV sales in just a few years. Fully 80% of new electric car sales in Norway now. EV sales are growing rapidly across the United States as well. So The evidence shows that a rapid transition to EVs is not only achievable, but being achieved. As to economic reasonableness, climate advocates presented evidence that EV costs are falling rapidly. With federal incentives in the Inflation Reduction Act, new EVs are projected to be cheaper than new gas vehicles by model year 2027 when the rule takes effect. The evidence also shows that an EV owner may save about $17,000 in fuel and maintenance costs over the lifetime of a vehicle. There is ample evidence in the record that the rule is achievable and economically reasonable, and the Court of Appeals will not second guess the board's decision to credit that evidence. On the second factor, the dealers have not shown the likelihood of irreparable harm. We don't know exactly when the appeal will be decided, but the dealers could ask the Court of Appeals to expedite consideration of the appeal, and I don't think any of the parties supporting the rule would oppose that. If the Court of Appeals decided to expedite the case, there's no reason they couldn't decide the appeal this year. Certainly, they could have decided it before the end of next year. The dealers fail to even articulate, much less explain, why a rule that applies to vehicles in model year 2027, which won't go on sale until 2026, will affect them at all in 2024 or 2025 while the appeal is being decided. Even when the rule does go into effect, there is no concrete evidence that the dealers will suffer irreparable harm. Dealers speculate that they will have trouble selling EVs in model year 2027, but that is just speculation. The world will be a very different place by the time these vehicles start showing up in New Mexico. We heard extensive testimony in November that EV technology is improving every day. EVs are becoming more affordable, range is improving, the charging network in New Mexico is rapidly being built out. There's plenty of time for the dealers to adapt to the changing market before these vehicles come to New Mexico in 2026 and 2027. So there's no showing whatsoever of irreparable harm in the short term. All the dealers have is speculation that they may have difficulty several years from now after the appeal is likely to already have been decided. That doesn't come close to the burden of showing irreparable harm. Finally, the public interest and the interest of the other parties weigh strongly against granting a stay. As Claudia Borchert from the department will explain, automakers are already taking advantage of the voluntary early action credit program. That is something that everyone should be happy about. It means we're getting more EVs to New Mexico.
Did not.
We heard a lot of public comment at the hearing about how many New Mexican consumers are having to leave the state to purchase an EV. The early action program will keep that business in the state. Entities that choose to participate.
Would be an hour. Some of our.
Sorry, hold on, Mr. Bach. We're hearing something. Chair Paul, sounds like you weren't muted. Go ahead, Mr. Bach.
Can I have a time check? I think I have.
No, I was on mute.
You have 6 minutes.
Oh, okay. I don't need that. Sooner. Early action credits mean that it's easier for manufacturers to apply in model year 2027. If a stay were granted, the primary real world impact would be to disrupt the efforts of companies that want to voluntarily get ahead of the game. Now, I heard Mr. Domenici say that they're not trying to block the early action program, but it's unclear how a stay, if a stay doesn't interfere with that, it's unclear what the impact the stay would have. It certainly is going to cause confusion for entities that are trying to get ahead of the game. And it's going to undermine the certainty that the manufacturers have expressed that they in knowing where to deliver their vehicles. All of this is going to mean that the significant environmental and public health benefits of the rule could be delayed or disrupted. All of these negatives clearly outweigh the dealers' speculative concerns. So to recap, the dealers need to show 4 things. They need to show that they are likely to win their appeal, even though that would be unprecedented. EIB's decision was supported by volumes of evidence, and firmly grounded in the agency's authority. Second, they need to show irreparable harm that will be decided that will happen before the appeal can be decided, which they cannot do, because the vehicles subject to this regulation won't go on sale until 2026. and the appeal can certainly be decided before then. Even in 2026, there's no reason the dealer should be harmed. There's plenty of time for them to adapt to the changing marketplace and continue to drive and sell vehicles in Mexico. Third and fourth, dealers need to show that a stay would not harm other interested parties and that the public interest supports a stay. Neither factor can be established. Stay would be disruptive, cause confusion, and potentially complicate voluntary early action compliance. That might mean fewer New Mexicans able to purchase an EV in the state, delaying or at least frustrating the tremendous public health and environmental benefits of the EV transition. For those reasons, we urge the boards to deny the stay motion. Thank you so much.
Thank you, Mr. Bach. Some of us have been at the dais for about 2 hours now. So let's take a 15-minute break and come back at 10:40.